Members, good morning. We have formed a quorum, and let's continue with scrutinizing the bills on the apology bill, and let's have the meeting started. Let's invite the administration team to join us, please. Yes, in the last meeting, the Bills Committee has finished scrutinizing clauses 1 to 7, and we've started scrutinizing clause 8, and we'll continue with looking at clause 8, especially in relation to clause 8.2. Members can also take reference from the CSA moved or submitted by the administration to us on the 8th of June, and that is CB4 12101617(01), and also another further CSAs submitted by the administration on the 15th of June, and that is paper number CB4 1248/1617(01). So can I now hand over the time to the administration to take us through clause 8? Good morning, members. We have sent you a letter on the 15th of June, and we've proposed a CSA. And we are focusing on the public interest or the interest of the administration of justice. And we have deleted the clause or the phrase "to all the relevant circumstances." And we have discussed clause 8 a number of times. So can I hear the members' response on our latest proposal in relation to clause 8? The latest amendment was made in response to views made by members in the last meeting, so we are having this latest version of the clause. So members, your views are welcome. Mr. Kenneth Leung. Good morning, Chairman and members. 8.2. We have discussed that for over a month. And I have also met face-to-face with some government officers, and I've made a number of studies on the clause 2 myself. As I said in the last meeting on clause 8.2, I agree to the administration's proposed amendment, and that is we should add in the phrase "the public interest" or "the interest of the administration of justice." I think this is a more pragmatic idea. When these two factors are considered by the court, i.e. the public interest or the interest of the administration of justice, then the court can exercise its discretion. So the discretion should be made after considering the public interest or the interest of the administration of justice involved. So I agree to this amendment. So I hope that other members will agree to my view. Ms. Claudia Mo. Thank you, Chairman. I am happy that you add in the phrase "public interest." I would like to seek a clarification now with regard to the news media. So whenever happens, when a case gets to court, then the court will definitely consider public interest. So public interest can be a very good defense in the court for the news media, and you are safe invoking that defense. Now here we are adding in the public interest as a factor. Would it be too wide, I mean the scope? But then for, say, if you talk about justice, and we aren't very sure about its meaning, but then for public interest, if the scope covered is so wide, then the court can exercise discretion really very often. Is that the case? Thank you, member, for your concern and your reminder. We said many times this is but just one of the factors, and the main criterion is that exceptional circumstances, or there is no other evidence available in determining an issue. That is stated here. So if we look at how the court will exercise its discretion, we have to bear in mind public interest and not private interest. And the decision maker must take on board public interest and also the interest of the administration of justice here. So, my colleague, any supplement? Thank you, Chairman. Can I add? When we talk about public interest, it may not, the scope may not as wide as you thought. In 2013, the Chief Justice of the Court of Final Appeal, at the beginning of the legal year, made a speech, and he mentioned about public interest, what's the court's consideration in that regard. And he made several points there. He said that it means in the court that in discharging the legal provisions, the court must uphold justice, fairness, and so on.
They also have to be able to enact the spirit of the law and have to base all the decisions on the principles of the law. So based on that, we can foresee that the courts will have to rely on this legislation, and we can be clear about their intentions. And in our clause 3, we have also said that it should be clause 2 rather, what the object of the ordinance is. So I think the courts will consider all of this when they consider the public interest and the special circumstances. The special circumstances have to occur in order to consider the factors I mentioned before they will have to execute their discretion regarding public interest. So there are some limitations to their consideration. Legal advisor, anything to add? The drafting of public interest and justice, my understanding is that the government has made reference to subclause 2, that is mediation, whether it can be accepted as evidence. They have to either accept or disclose this information. It has to be in the interest of public. It has to be in the public interest, and it has to be just and equitable to do so. Next, we have Mr. Yu Chong-yim. Thank you, Chairman. Thank you for the legal advisor's supplement regarding the mediation ordinance wording. I was going to ask compliance. Could you amend concerning to compliance? English, I think it's having regard to, that is, if there is a lawsuit, as long as they had made regard to, but ultimately did not comply with public interest, then the judges can say that they had complied with the legislation, but they had considered, but it was not in accordance. So, as legal advisor said, so if we rely on the mediation ordinance, it has to be in compliance with public interest, and it has to be just and equitable to do so. Okay. government officials, any response? Chairman, we understand that the drafting has to reduce the uncertainty. So the current drafting, we believe, meets that requirement. Regarding, in regard to, it should be very clear what the requirement is, and it should give the judges some direction. So the principle of complying with public interest and being just and equitable, this requirement has been stated. Well, the example I gave you just now was that, are you worried that there's non-compliance? But they claim they had already made, they had given regard to such a consideration. Government officials? Chairman, I'd like to respond. The amendment on this occasion, the most important clarification is of a major principle. In the drafting, we require a special condition, and the judge has to consider the major principle is whether it is just and equitable. So the public interest or the administration of justice requires the judge to they have to consider what is just and equitable, and they have to consider two clear factors, that is, a public interest or serving justice being seen to be served. So the drafting is not exactly the same. In the first instance, we don't state the big principle of being just and equitable. Well, you mentioned that in 2013, the Chief Justice, in the opening of the legal year, he had stated how the courts understand public interest. And in our bill, the scrutiny of the bill, a lot of our colleagues have said that it's not just all the relevant conditions, it should be based on public interest. And if you accept the bill committee's suggestions, and now you've changed the drafting, it's not just all conditions, it's public interest and being just and equitable. So the Chief Justice has said that their understanding of public interest, you said it has to be just and equitable, but now your drafting says it's just fair and just. So your drafting is not the same as the Chief Justice understanding of public interest. That's why our colleagues have required an addition. And you said just regarding to, in regard, you just added that clause, and you say that the judge will have considered that, but that is against public interest, even if it is just and equitable. So we have just wanted you to add public interest and being just and equitable. If we don't have that safeguard, then the discussion over the past few weeks seems to have left out our requests of the addition. Well, Chairman, when we read the legislation, we have to read it as a whole. The legislator had reminded us to read it once again, and in the drafting it says that only if the decision maker is satisfied that it is just and equitable in order to execute that discretion, in order to exercise that discretion. So it has to be just and equitable. So I don't see under what circumstances they can say that it is public interest, but it is not just and equitable. So our drafting is very clear, and it has to be just and equitable. So I think that should take care of legislators' concerns. Well, I've heard colleagues' suggestion. So perhaps we could understand it that there is a concern that it is not of public interest, and then we have a certain outcome. So if we make that claim, then can we say that if it is not in compliance with public interest, so it is not just and equitable, but there should be two further layers. If you consider public interest and it doesn't comply with public interest, then you cannot exercise that discretion. If you consider public interest and it seems that it complies with public interest, then there should be just and equitable. So then you can exercise the discretion. So if it's not in public interest, then you don't need to exercise the discretion. But if you consider, if it's not in public interest, then you won't exercise the discretion. I'm not sure if you are understanding it along this line. I understand it exactly the same. The drafting has highlighted a special condition in order to exercise the discretion, because we don't want to remove the apology. It has to be in the interest of public interest. It has to be of public interest, and it has to be just and equitable. That is a very high threshold. So we would like to express that whether apology evidence can be admissible and whether the decision maker can adopt that evidence, the threshold is very high and very clear. Mr. Leung Kai-Cheng. Well, I heard Mr. Yu Chong-yin. I understand your starting point. I have a suggestion. The government can consider that. Mr. Yu is concerned that the phrase "having regard to" that is not the way it's drafted is not as effective. So, law draftsman, if you replace "having regard to" with "taking into account public interest and administration of justice," so the taking account is used in a lot of law drafting. So could you consider that phrase versus "having regard to"? Is there any difference in impact? Does it meet your drafting intentions? It's just for discussion. Okay, let's see. Government, do they have any response? I'll defer to law draftsman. Thank you, Chairman. And our view is that if we replace "having regard to" into "taking account," the meaning is similar and it matches the Chinese Gu Cup. So our colleagues had already explained clause 8 bracket 2, the decision maker has to accept whether it is just and equitable in order to exercise the discretion. So in that decision process, we've provided some guidelines. That is, initially it was all considerations, and now we've divided it into public interest and whether it's just and equitable. So that is the final test. Legal advisor, I'd like to clarify that we were referring to clause 10 bracket 2 in the mediation ordinance. It says taking into account, and in Chinese it's 说好了. And just on the wording alone, it doesn't say that it has to consider public interest. It just says that the court has to consider disclosure or whether admission of evidence is of public interest and whether it facilitates the administration of justice. So if it's not in public interest and if they continue to do so, they would stand a high chance of being judicially reviewed. Mr. Yu Chong-yin. Well, if that's the case, fair and equitable shouldn't you use the Chief Justice wording for fair and equitable? Otherwise, you would seem to have some discrepancy. Government officials, we don't see why it's not in accordance. The basic assumption is the same. It's public interest and being just and equitable. We have to read Clause 8, Bracket 2 as a whole. We have already stated very clearly there has to be extenuating circumstances, such as there is no other evidence available for determining an issue, and if we were to exercise discretion, it has to be, the decision has to satisfy it being just and equitable, and we have to have regard to all the relevant circumstances. I think that is very clear, and the intention has made clear. Our colleagues have some supplement. In bracket CB4 1085 bracket 7, we talked about fair and equitable. It's not a new concept. In English it's called just and equitable. There is a special meaning. In paragraph 17 we had said that this is not a new concept, and secondly, in Hong Kong existing laws it has occurred 90 times, so we did not make an arbitrary choice. We had thought about it carefully. And why did we have to mention public interest and so on? It's because we took on board legislators' views and wanted to clarify it and remove uncertainty. Therefore, we made that amendment. Well, if we refer to the mediation ordinance, how would it be inappropriate when we say that we have to consider whether it is a public interest and it being fair and equitable?
Government officials, please. Chairman, as my colleague pointed out, we have taken on board members' views before we come to our present drafting, and I think the wording is clear as far as the requirements of the law is concerned, and that is, it is just and equitable to do so having regard to the public interest or the interest of the administration of justice. So that sets out what the decision maker has to consider, and I hope that the members would accept our proposal. We have taken on board members' views, and the wording has been made clear as far as the drafting is concerned. So the public interest or the interest of the administration of justice have been set out clearly. Okay. I would like to share my view here. In relation to clause 8, bracket 2, if my memory serves me right, and as pointed out by Mr. Kenneth Leung, we spent quite some time in our past several meetings discussing clause 8, bracket 2. Well, we've discussed it for over a month. Of course, I welcome suggestions still from members, and Dr. Edward Yiu also raised some scenarios and cautioned us to be more careful, and I understand that. But from the early days of our discussion up to now, the administration has really accepted members' views, and they've come up with several rounds of amendments, and finally we are seeing the final version today. My observation is this: after several rounds of amendments, if you remember what happened in the last meeting, several members also already said that they accepted the amendment to clause 8.2. And this latest amendment was made in response to members' views last time that the drafting should yet be more accurate and concise. Now, we've discussed Clause 8.2 for quite a long time, and my feeling is that you generally accept this. So can you agree, or can you accept this latest version? Now, if that is agreeable to you, then we can move on to the next clause. Other members, do you have any other views? Well, if there is no other view, then let's move on to Clause 9. Administration, please. Take us through Clause 9, please. Thank you, Chairman. Clause 9 has to do with the apology, not a limitation ordinance acknowledgement. And it sets out clearly an apology made by a person in connection with the matter does not constitute an acknowledgement within the meaning of that ordinance in connection with the matter. And the limitation in the timing of that ordinance should not be extended, and we should try to we are trying to remove a barrier to apology. The limitation means the time allowed to take an action. Say, if a plaintiff is involved in a civil claim, say, admits the liability. Now, if that is done, the time allowed for the case will be extended. Now, if there is apology, the limitation in the timing may be sort of removed and the period may be extended. And very often because of that, a lot of people would not like to make an apology because of that, including a full apology acknowledging full liability. So in order to remove this obstacle for people to make an apology so that they would not have to worry about the extension of the time, then we are suggesting that an apology does not constitute an acknowledgement within the meaning of the limitation ordinance. Thank you. Any views on Clause 9? Government representative. Now we have resolved 8.2, and what about Clause 8.4 about decision making? Do you have any further points to make? It applies not only to a court, but also other proceedings as well. Do you think you need to say something more on that? Yes. Okay, let me try to explain more about the meaning of decision maker. As we said earlier, can I refer you to Clause 8? It sets out the applicable proceedings, including judicial, arbitral, administrative, disciplinary, and regulatory proceedings. And for all these proceedings, there will be a decision maker who will deal with the disputes and say also disciplinary decisions and so on. For these various proceedings, the decision makers may be a single person or two or more persons. So, in defining decision maker in relation to the applicable proceedings means the person or two persons or more. So the definition is quite wide. So it includes an individual, a corporate body, a mediator, or arbitrator, or any other body or individual. So that's how it is defined now. Understand? Okay. Now we are done with Clause 9. Let's move on to Clause 10 then. Thank you, Chairman. This is an important clause in the bill because one of the things set out here is a major obstacle to making an apology because the person involved may be worried that an apology will affect clauses in a contract of insurance or indemnity, and the person may not get the insurance or indemnity owed and he entitled. So we said that an apology does not avoid or otherwise affect any matter under a contract of insurance or indemnity. We think this is important. So we hope that this clause can remove people's worries towards apologies. Thank you. Member, any question on this? Legal advisor has something to say. Yes, I have a question. 10. 1. Now, if the insurance contracts said that the arbitration should be made in Hong Kong, but then people are choosing, say, other laws like New York laws applicable. But if, say, in the laws in these other jurisdictions, there is no similar law as a Clause 10.1. So it means that the person will not be entitled to the claim. So what happens if the arbitration is done in Hong Kong and must compensation be made? Say, if we use the governing laws of other jurisdictions, how will you deal with that? Thank you. Legal advisor, for your question. I must say that people involved have to be very careful about the exact contractual terms in the contracts and what the governing laws are. The legal advisor mentioned two things. One is the substantive law. If the substantive law is not Hong Kong law, then, of course, after the bill is enacted, the bill is not applicable to that contract. But if the civil proceedings or the arbitral proceedings are conducted in Hong Kong, Hong Kong's procedural laws will apply. So if that is the case, after the bill has come into effect, then the law can apply. And we said that apology should not be admitted as evidence in proceedings, including arbitration, except that there are exceptional cases, as mentioned in 8.2. Now, in response to the questions raised for proceedings done in Hong Kong, including arbitration proceedings, this bill or this law will apply. Can I further follow up? The legal advisor's question is, say, if the insurance contract, so governing law, say, is the U.S. law. Now, that's an assumption. And for one reason or another, the arbitration is ultimately conducted in Hong Kong. But for the contract signed between the insurer and the insured, the governing law is U.S. law. So in that case, does Clause 10 apply? Because this clause says that this contract will not affect your insurance cover. But then for the contract, if it is its governing law is U.S. law, will the contract be affected because there is an apology and then they don't have to making compensation? I'm not talking about the proceedings, but then if it is set out specifically in the insurance contract that is a condition, then would that insurance cover be affected? Can I defer to my colleague? Chairman, well, let's clarify the objective of the bill, and that is, well, as we said in Clause 8, and that is whether an apology is admissible in applicable proceedings as evidence in Hong Kong. Well, that is the crux of the issue that we want to address in our bill. The bill seeks not to change the governing law of a contract. Now, say if a contract's governing law is an overseas law, the usual practice is that we will not bring that overseas law under our coverage. We don't want to change the substantive laws of overseas jurisdictions. That's not our intention. So in response to legal advice's question, say if there is a proceeding conducted in Hong Kong, for example, it's a court proceeding, it's an arbitral proceedings, and people opt for Hong Kong as the place for conducting the proceedings and the arbitration. Now, in that case, when the decision maker considers whether an apology is admissible as evidence, the decision maker has to use the Hong Kong laws to make the decision. So that's how the proceedings should be like. He should opt for Hong Kong laws because the people involved have opted for Hong Kong as the where the proceedings are to take place. So in that case, in accordance with Clause 8, first of all, the court or the arbitrator cannot accept an apology or admit apology as evidence. So the apology is not admissible as evidence. So when the court considers the contractual terms or the insurance coverage, it should not consider the insured's apology because that cannot be admissible as an evidence in court. Thank you, Chairman. Yes, understand. I see if members have other views.
So, I understand what you have said. So, if Hong Kong courts will not admit that evidence, and if they don't accept the apology as evidence, then the insurance contract cannot be made void and say because you apologize and we won't make compensation. So, even though the contract would mention governing law being in a different jurisdiction, but as long as it's the procedure is conducted in Hong Kong, we will apply Hong Kong laws. Chairman's understanding is correct. The decision, the arbitrator or judge, they cannot consider whether the contract is valid or not. They cannot consider that somebody has made an apology. Since that cannot be considered, then in the court proceedings or in the arbitration proceedings, we have to proceed as if nobody had made an apology. So whether the contract is valid or not, they cannot consider the apology. I understand Mr. Paul Che has raised his hand. I'm not an expert in mediation or arbitration. But just now you explained that there was a difference between substantive law and procedure law. So let me give an example. Let's say an insurance company has received a declaration from a U.S. court, and if Hong Kong recognizes that declaration, then they will have bypassed the procedural barrier. They can use the results, the outcome from the substantive law, and bypass the Hong Kong procedure. Have you considered that? Thank you, Chairman. Thank you for the question. Let's say they want to implement an award from an overseas jurisdiction, then they need to comply with the apology ordinance because in the U.S. they have dealt with that matter. There's already a court ruling. They don't need to come to Hong Kong for another lawsuit, so they don't need to use the clauses in the apology ordinance to conduct a lawsuit. they would come directly to the courts and to seek their award recognition. They would not need to conduct a lawsuit again according to the apology ordinance. Well, for technical issues, if they get a U.S. declaration, they might not seek a full enforcement proceeding. They might not be going after an arbitration award from the U.S. and exercise the law according to the New York Convention. So it might not be such a comprehensive procedure, but let's say regarding the contractual outcome or the legal outcome, what is the effect of the substantive law? They might not seek to enforce the whole award in Hong Kong. They just get the declaration and use that declaration to bypass your procedural barrier. So you do acknowledge their award, but if they don't adduce evidence through this door, but they can do so through other means. So is there any opportunity for conflict? I'd like to supplement to Mr. Paul-Tse. I'll take it a little bit more extreme. As Mr. Paul-Tse said, they do not need to complete an award. Let's say within a certain U.S. state, there's a clause in the contract, and they want to clarify that clause states clearly, if you make an apology, then the contract will be void, and I'll just focus on that. So, assuming they come to Hong Kong, the first thing they'll say is that when you sign the contract according to the laws of a certain state, whatever apology you make, it will void the contract. So if that occurs, will that meet what Mr. Paul-Tse has mentioned? Will that scenario occur? So government officials, could you elaborate on that? Chairman, we had already answered that question. If they conduct a lawsuit in Hong Kong, let's say that the contract is based on U.S. law, then the substantive law would be U.S. laws, and we need expert witnesses to help us in Hong Kong regarding U.S. law. But regarding the procedure, we will be using Hong Kong laws. So previously, the legal advisor had given us a written question, and we had responded. So you can make reference to the document CB4-1086/1617, question D. The legal advisor had quoted a Canadian case, and we had done some studies how it would apply in Hong Kong. So the conclusion is that in Hong Kong procedural law, even though the substantive law is from overseas jurisdiction, we will still be using the Hong Kong procedural law, as our colleagues mentioned in our clause, draft clause 8, whether evidence is admissible. This is procedural law. So when Hong Kong courts try the matter, they will look at evidence. They will have to comply with Hong Kong procedural law, and the apology is not admissible as evidence. So even though the insurance company says that the other party had made an apology and therefore the contract is void, but evidence-wise, that apology is not admissible. Of course, they can make such an allegation that the apology was made, but then they can make that statement, but there's no it is not admissible as evidence. It will safeguard the person making the apology. Mr. Leung Kai-Chiang, Chairman, I need to explain in greater detail. The government officials have not been able to explain clear. Let's say a commercial contract, including an insurance contract. Of course, the governing laws are made very clear, It might be New York state law or California state law. That's the first thing. The insurance company and the insured party will be very clear. So the second thing, whether it is arbitration or a court proceeding, unless it is made clear in the contract, if there are any disputes, both parties will argue. So I assume they said that it is subject to arbitration or subject to court proceedings, but the both parties' lawyers will be arguing where does the jurisdiction belong. Even though the substantive law might be New York or California state laws, but when there's a dispute, unless the commercial contract says that it has to be dealt with, the court proceedings have to be dealt with by California courts. Otherwise, both parties will say that let's have it tried in Hong Kong because the insured party is based in Hong Kong, or the client is a Hong Kong company. We have to. So if we do it in Hong Kong, then then as the DOJ colleagues say, that Hong Kong procedural law will apply, even though the substantive law might be New York or California. So where the court proceedings or arbitration is conducted is dependent on the jurisdiction. So unless it's stated very clearly, it has to be done in California. So I think the principle is that the buyer, the consumer, has to beware. So when we draft the apology bill, the insurance industry and the government also has a responsibility to explain to the insured parties. I understand Mr. Paul Jay's concern that under a very small number of circumstances it will occur. The contract says, it states the governing laws, and it says that arbitration has to be done in a certain place. Then the insured party, after they make an apology, the outcome is not so good. Mr. Paul Jay, I'd like to take the discussion a little bit further. We're expending our effort we want to promote business, so will it give rise to all the arbitration cases and to be taken away from Hong Kong because all the substantive law is an overseas jurisdiction, but because Hong Kong might be chosen as a venue for arbitration, but the procedural law affects the outcome. So just for clarity, they might take all the cases back to their jurisdiction. So will you be driving business away? I'll let Mr. Leung Kai-Cheung, or you want to hear from the government officials. Well, the outcome, will it take business away from Hong Kong? Will that occur? Well, first of all, the apology ordinance exists in a lot of countries: Australia, Canada, US, UK, and Scotland. So that's the first point. We're not unique. Will all the arbitration cases disappear? That's not a large possibility. Second, we're saying that an apology is not an admission of guilt, and it should not affect the insurance. What we're regulating is that typically the insurance contracts, they don't want the parties to make an apology because they are the insurance companies don't want to be responsible for the liability. So the ordinance just requires that an apology not being an admission of guilt, and the insurance companies' position can be made clear. So if the contract is not spelled out where the arbitration will be conducted, then we do have a common law to deal with that, and we already have if the contract doesn't spell out where the arbitration will be held, common law can already deal with that. So, for commercial agreements or contracts and how they deal with disputes, typically they will spell out where they will spell out which courts or which jurisdiction will be the venue for arbitration. Typically they will spell that out. Mr. Paultier, we're afraid that they already spelled it out clearly. In our experience, insurance companies, when they have substantial risks and they have to make a payout, they will seek out all the advantages to avoid payment. So for some countries, an apology can make the contract void. So if an apology can be a defense used by the jurisdiction, this will be used and most likely be abused as well. So if there's no removal of risks, if it still exists, or if it can be revived, then we should pay attention to this risk. I'm not objecting to your direction. I'm just afraid that there are some areas that we have to be careful, that's all. Mr. Leung Kai-Cheung. Thank you, Mr. Paultier. Paul is very meticulous in scrutinizing the law. So if we look at it objectively, you're saying that even insurance companies might apologize. So if they use Hong Kong jurisdiction, it would be beneficial to them. So the insured party might apologize, and if you choose Hong Kong to do the proceedings, it might not be the most beneficial. Well, of course, that the probability is the same for both cases.
I know that in relation to Clause 10, I believe the insurance sector has forged a consensus and there has been consultation. I think what matters most is to educate the public. The public must know that the insured person has his own right and how he's affected under the ordinance, and that's important. I've asked this before. After the apology ordinance is enacted, does the government have any plan to launch major publicity exercises? Thank you, Mr. Leung. Government team, please. Thank you, members, for your questions or comments. In response to Mr. Paul Chair's question, his question seems to be asking that on substantive law, will insurance contracts be covered by Hong Kong laws or overseas laws? Now, our bill is that at this stage we are not going to change or amend substantive law in overseas places. Say if I buy out an insurance contract and we've decided on overseas laws to be the substantive laws, then at this stage we don't have any plans, say, to change that. If we want to actually change the applicability of overseas laws, the substantive laws of insurance contracts, we have to tread very carefully, and that's something for the future. What we are dealing now is contracts covered by Hong Kong laws. As for the case where somebody wants to circumvent the law, we may have to do a lot more public education so that people can make a decision on whether to have the governing laws of his insurance contract being Hong Kong laws or overseas laws. I think both parties have the freedom to decide on that. So the insured person can make a decision on whether his contract will be covered by overseas laws. Well, he has to think carefully about whether he wants to do that or not. The members of the public should pay attention to that particular point. And going forward, we would be also keeping close tabs on how the law is implemented and whether there are irregularities that we have to handle in the future. Mr. Porter, members of the public take out a lot of insurance, especially, say, car insurance. Now, big insurance companies may seek legal advice when they sign out insurance contracts, but for individuals, they can't do that. Now, can the administration consider when, say, insurance products are being made available in Hong Kong involving consumers' interests, should they be just limited to using Hong Kong laws so that people will not be fall into any pitfalls? Mr. Paul Chair mentions the possibility of people trying to bypass the laws and resorts to all ways and means. Now, going by our experience for, say, preparing contracts, we may decide on choosing the laws of a certain place to be the governing law, and also how the where the court proceedings or arbitration should take place. Well, these are all set out in the contracts usually, but then members of the public do not have a good bargaining power. But for big companies, they have come up with very clear terms. So do you have any views on that? Thank you, Chairman. In our consultation, we heard views from the insurance sector, and they support the apology bill. Their main consideration is that mediation or arbitration can be done as soon as possible. And if the cases go on, that would not do any good to them and the consumers. They would try to resolve the dispute as soon as possible. But then there may be some other insurance contracts which are more complicated. But that may not be involving the average consumer. In Hong Kong, we've heard members' views here. I think we should continue to communicate with the insurance sector, and at the same time do more public education so that the public can be more careful and consider all factors in entering into an insurance contract. Legal advisor. Well, in the paper 410A1617 item G, I have raised a similar point. If the object of the bill is to protect the insured and also the average consumer, and so that they would not opt for overseas laws as the governing law, then they can consider Cap 458 Clause 7. And that if people deliberately opt for overseas laws as governing laws, and if one party is the Hong Kong public, that means the Hong Kong laws will still apply, and the governing laws will be void. So it's a matter of policy, really. Thank you, legal advisor. All right. Any other views on Clause 10? Mr. Kenneth Leung, can the administration tell us, before the ordinance commences, do you have any plans on public education and publicity? Chairman, we would try to publicize the law extensively, and we try to achieve the policy intent. We would try to encourage mediation, try to prevent the escalation of disputes, and facilitate amicable resolution of disputes. We will issue pamphlets, and we will liaise with various actors of the community to publicize the law. We will also arrange for seminars and meetings to spread all the messages. Thank you. After the law commences operation, I hope that you can continue with your public education work. And I believe no law is a perfect one, and it takes time for it to sort of develop and become better. And I think it's good that we have this law. We take the first step, and then we will try to improve afterwards, bit by bit. All right. That's it for Clause 10. Can the administration take us through the remaining clauses, please? Thank you. Clause 11, it says that this ordinance does not affect disclosure or of documents and other applicable proceedings. And also for the defamation ordinance, in that ordinance, apology can be admitted as evidence and try to cut down on the damage and the compensation. So here it says that it will not affect the operation of sections 3, 4, or 25 of the defamation ordinance. And also in the mediation ordinance, there is also a clause on the confidentiality of certain communication. So this ordinance will not affect the relevant clauses in the mediation ordinance. We want to stipulate this clearly, that the gist and the spirit of the apology bill. So that's it for this clause. Thank you. Legal advisor, I have a question. 11A, it doesn't affect disclose, produce documents, discovery, etc. in application proceedings. How do you do with apology letter? Well, do we have to disclose this letter? And in regulatory and disciplinary proceedings, if a summons is issued asking the other party to present the apology letter, does the letter have to be presented? Legal advisor. Thank you, legal advisor. He is asking the first point. In legal proceedings, there is a disclosure procedure. Does the apology letter have to be presented to the other party? We are talking about two separate matters here, disclosure and admissibility. For discovery process, whether the documents are to the person's advantage or disadvantage, they have a responsibility to discover or disclose that. And the ordinance says clearly it will not affect that process. So in the discovery or disclosure process, such documents have to be disclosed. So it means that they should not put, say, all documents under this apology ordinance and they don't have to present these documents. No, that's not the case. Second, in disciplinary proceedings, when there is a summons issued to seek for a certain document, that's something different. That doesn't fall within the disclosure of documents proceedings and civil proceedings. Normally, the magistrate court will not issue a summons to require or seek for documents. It's usually one side of the party will ask for summons requiring the other party to present the document. the document on which the document is required to be produced, he will say that because the documents contain an apology and it is protected by the law, then they will object to presenting the documents. The committee will hear submissions from both sides then, and then they will make a decision on considering the apology ordinance to see whether the requirement should be fulfilled. This is what's happening actually too. Somebody asks for a document to be produced. The other side opposes for certain reasons. For example, because of the legal privilege reasons, the other side will refuse. And the document will be presented to the court first, and which will decide whether the document should be protected. Now, after the law is the apology ordinance comes into effect, the same requirement or proceeding will apply. So the disclosure of documents in certain proceedings and also the magistrates' courts for the requirement to produce certain documents, these are two different matters. Mr. Paul, Chair, I hope that the apology ordinance can move a step forward. For some documents, they may not fall under the ordinance. But for some other documents, they should be discoverable, especially when you consider 8.2, when there is exception, for considering whether it is just and equitable, then different considerations may be taken on board. Now, in the discovery process, whether an apology as of right should be discoverable. Now, if they don't produce a document, will we be having further disputes? Thank you. We agree with Mr. Chair's worry. So that's why 11A says out clearly that the ordinance does not affect the discovery process. So the apology maker cannot say put everything into this apology document, and then they say that because there is the apology ordinance, they don't have to produce a document.
So in a civil proceeding, you still have to make these documents available. You cannot hide everything just because there's an apology ordinance. Mr. James Toh, I want to follow up on that question. Our principle is that if you apologize, then it cannot... it's not an admission of guilt. So let's assume A apologizes to B in a written form, and let's say there are 5 reports, 8 tests, and 10 facts, and submit to B and apologizes to B, and they have the contents of the wrongdoing. So all the tests and so on, is that not in the discovery list? Or can they disclose that and say that that is not an admission of guilt? The government officials. I think what will happen is, because of 11A, the apology letter and the attachments, the 5 letters and the 10 tests, so on, have to be disclosed. So in the disclosure, aside from the written letter, you can also require that to be submitted independently. So at the court proceedings, the plaintiff can quote the facts and the reports. Of course, they cannot quote the apology letter, but the documents can be admitted as evidence in the courts. Okay, that's explained. So I'm aware that the plaintiff is suing the hospital or the driver. So they are aware of these reports because in the enclosures they are made aware of they require the reports to be disclosed, and if it's advantageous to them, then it won't be because of the apology, and it will not be admissible, and it will not because of that be made not admissible in court. Okay, any further questions on Clause 11? Mr. James Toh? The government's new Clause 8.2, having regard to the government, will they reconsider that? Or is this the final version? Well, my understanding, you weren't here. I had consulted everybody, and we've gone through different versions, and the final version we have, and since we spent a lot of time on it, it has been accepted. And in the last meeting, quite a few members had accepted the version. So based on that, we will work with the government's amended version. That's roughly what transpired. I agree with the current version. Just now Mr. Leung suggested take into account. I have no special stance. I will also agree with the government's version. Thank you. I want to clarify, this is the final version. Okay, so we have a confirmed response. So, any other questions on Clause 11? If not, please continue. Thank you, Chairman. Clause 12 states that the Chief Executive in Council may, by notice published in the Gazette, amend the schedule. In the previous meeting, we had talked about the procedures of amending the schedule and the procedures not applicable. So now we've set aside some flexibility. Upon accumulating further experience of the apology ordinance, we can amend the schedule, and it will be done through the Chief Executive in Council. And okay, so Clause 13 is the end, and then we move on to the schedule. So will we deal with Clause 13? Thank you, Chairman. It points out that the ordinance applies to the government. Okay, that completes the bill, and now we're left with the schedule. So let's deal with the schedule, and it is not applicable to. Could you explain the CSAs? Thank you, Chairman. The schedule has 3 not applicable proceedings. Proceedings conducted under the Commissions of Inquiry Ordinance, and proceedings conducted under the Control of Obscene and Indecent Articles Ordinance, and proceedings conducted under the Coroner's Ordinance. Previously, on the 8th of June, we had put forward a CSA, and we will include proceedings of the Legislative Council, including proceedings of the committee, panel, or subcommittee established or mandated by the Legislative Council to discharge a function or exercise the power of the Legislative Council. These are not applicable. So why did we include the first 3 items? In our previous meeting, we had stated that these are factual rulings. It does not touch upon wrongdoing, or so the apology ordinance doesn't apply to those cases. So in LegCo proceedings, we had explained, we feel that the Legislative Council has its own procedure, and the government respects its functions. So we feel that the apology ordinance should not apply to LegCo proceedings. Okay, thank you, government officials. I'd like to mention that in our previous meetings, I had asked everybody, and the consensus was that LegCo has its own procedures that need to be respected. So the apology ordinance, we felt that it should not be applicable to LegCo, and because of this, the government has made a CSA, so they added that to the schedule, and the wording has been drafted. That includes proceedings of a committee, panel, or subcommittee established or mandated by the Legislative Council. So if you have scrutinized the CSA and you have no opinions, I think the bill committee can accept the CSA. Do you have anything else to supplement? If not, I think we have completed the CSA and the schedule. So I'd like to ask, we have completed the Chinese version of the bill, and I'd like to ask the legal advisor or the government officials, do they have any comments on the English version, or do members have any questions on the English version? Legal advisor? We had scrutinized both the Chinese and English version and no questions. Government officials, nothing to add? Okay, thank you. So we have completed clause by clause scrutiny, and if there's no need to convene a further meeting, then we have completed the bill committee's work. So I'd like to ask the government, the resumption of second reading arrangements, do you have any target date or view on when we should resume the second reading? Thank you, Chairman. We hope that we can resume the second reading on 12th of July, and we will follow the schedule for the rest of the work. So if we all feel that 12th July can be the target date for resumption of second reading, then I have a suggestion. I can go through the steps required in the future. I suggest that on 23rd of June that I submit a verbal report to the House Committee, just a verbal report. And on 3rd of July, or before 3rd of July, we'll put forward a deadline for the CSAs, and on 12th of July, on the LegCo council meeting, we'll resume the second reading. And the dates I mentioned are those are the dates that we need to bear in mind of our work. If we don't have further questions, we will proceed according to the workflow. And I want to ask, do you have any other business? If we don't have any other business, I'll announce that the meeting adjourned, and our bill committee has also concluded its work on the apology bill. Once again, we have to thank the government officials, the legal advisor, and the secretariat for all their work. Thank you.